My name is Benjamin Bakari. I am the co-chair of the group, along with Daniel Norkin. I am the founder and CEO of a company called Abachi Inc. It's a digital asset startup. And today we're going to put on a webinar series of U.S. securities laws, rules, and regs around the digital asset landscape. I am an attorney, so this is just a disclaimer. This is not legal advice, nor does it create an attorney-client relationship. This is for informational purposes only. If you do have any questions following this webinar, we will have a Q&A for EEA members, and then you can reach out to me at your convenience after the presentation. So the agenda today, we're going to talk about the Securities Act of 1933, the Exchange Act of 34, some federal case law, what's better known as the Howey test, and then I'll take you through some examples of financial instruments as securities, and then we will delve into crypto and digital assets and security token offerings and Ethereum token or security token standards. All righty, so from a very high level, I know everyone is familiar with securities law to a certain extent at least, but I think there is a significant gray area in how we apply existing law, old law, to this new Web3 landscape. So the statutory definition of a security, here on the screen under point 4, that is the statutory definition under the Securities Act. And it's essentially a financial instrument secured by a certain type of valuable asset. Securities can be backed by revenues or profits of the company, and traditionally speaking, they are issued and purchased by signing transaction documents, such as share purchase agreements or subscription agreements. Now, these acts were implemented following the 29 stock market crash, and it was basically it came to fruition because of fraud and similar misconduct led to speculation in markets that was aggravated by market manipulation, which resulted in the crash, and that led to significant loss of confidence in financial markets. These acts together complement a complete disclosure system that require registration reporting for issuers of securities and anti-fraud provisions. Now, the 33 Act, as it says here, governs offers and sales of securities in the market. The Exchange Act governs security transactions in the secondary market after issuance. What I don't have on here, but what is relevant, is also something called state blue sky laws. Every state has securities laws that regulate the offer and sale. However, a lot of those provisions and issuers can be exempt from those security laws, except for anti-fraud. And the reason is just to streamline markets and reporting requirements at the federal level. Okay, so the Howey case. For everyone that doesn't know what Howey was truly about. So in Howey, a company sold small tracts of land in the citrus grove. And the individuals could service the land, but they lacked the expertise to actually cultivate citrus trees. They invested in it for a profit, and the service contracts granted Howey Company possession of those tracts. The individuals had no ownership of the land or the crops, but they were allowed to share in the profits of the enterprise. The Howey court determined that that offering, coupled with the contract for cultivating the citrus groves, constituted an investment contract under the Securities Act. The principal question that the Howey court considered was whether that land sale contract, together with the service contract for the Howey Company, was an investment contract. Under point 3, that is the specific phrase that was included within the opinion. From that, we get the Howey test, those 4 elements listed under point 4. So investment of money in a common enterprise with the expectation of profits derived from the efforts of others. An investment of money can be any form of consideration with value. So cash, investment of services or property or cash equivalents like Bitcoin or Ether. In a common enterprise, otherwise known as commonality. This element focuses on the profitability of the investment and whether or not it's dependent on the success or failure of the enterprise. Now, commonality has two different measures. There's horizontal commonality, which basically draws lines with multiple investors. So funds pooled together, or if their returns fluctuate together. And then vertical commonality, and that's between promoters and investors. With the expectation of profits. Profits can be in multiple forms, such as capital appreciation, cash return, or other earnings like dividends or interest. An important distinction for this element is when a purchaser is motivated by desire to use the item purchased instead of profit-seeking opportunities. And then last but not least is the fourth element, derived substantially from the managerial or entrepreneurial efforts of others. The principal focus in this element is quote unquote, the economic realities of the underlying transaction. And we'll get to this a little later, but this element, some courts, both state and federal, have considered as the risk capital test. And that basically differentiates between active and passive participation. So taking that together would mean investor participation is necessary to realize a profit, or is it just incidental, not necessary to realize that profit? All right, and the other case of relevance here is Reves. So the Exchange Act and the SEC specifically exclude from the definition of security that we looked at earlier, notes with a term of less than 9 months and the proceeds of which that are used for current transactions. In Reves, SCOTUS, the Supreme Court, explored whether an instrument denominated as a note fell within the definition of a security. Now, the Reves court did not employ the Howey test, but rather they adopted something called the family resemblance test. That test has 4 elements, as noted under point 1 here. So motivation of the parties to enter into the transaction. It's more likely a security if the motivation is to raise money and the buyer is interested in profit-making opportunities. It's less likely that a note will be considered a security if it is purchased to sell a consumer good, to correct a seller's cash flows, or to advance some other commercial or consumer purpose. Plan of distribution, like I said earlier, it's more likely a security if the note is speculative or it constitutes an investment opportunity. Reasonable expectations of the investing public. So, what is the motive for investing money? Is it profit making, or is it consumptive use for a good? And then last but not least, the presence of an alternative regulatory scheme. It's less likely a security where there's an alternative regulatory scheme that reduces the investment risk. Now, under point 2, there are examples of instruments that are not securities. These taken together can be considered as short-term commercial loans. And they are not the types of instruments that can be easily traded. And so to give you another example, notes that are used for short-term lending transactions, basically for closing an acquisition as opposed to permanent financing, would not be considered securities. Conversely, if a note shares the characteristics of a corporate bond or a debenture, for example, the value of that, which fluctuates with the success of the issuer's business, or it has a term of several years for maturity, can be easily traded, that is more likely to be considered an investment and thereby a security. Okay, so those are the 2 prominent cases that we see today. And keep those elements in mind as we go through the rest of the presentation. Now, examples of financial instruments as securities. So stock, obviously, courts looked at dividend rights, negotiability, rehypothecation, voting rights, and value appreciation. Now, notes. So as stated with the Reves case, there's a rebuttable presumption that all notes are securities. This means that one must show that the note bears a strong resemblance to one of the common law categories of instruments that have been accepted from the statutory definition of securities. So that would go back to looking at the definition under the Securities Act. And SCOTUS has repeatedly held that for all intents and purposes, the statutory definition of security is one and the same. It's very consistent under both the Securities Act and the Exchange Act. Another way of looking at this would be an investment versus a commercial purpose. If the investment motivation is primarily for a profit-making opportunity, it's likely a security. But if it's for a commercial purpose or for consumptive use, likely not a security. Certificates of deposit. So CODs are not securities. Typically, they're issued by federally regulated banks. They're subject to a whole comprehensive set of regulations. And deposits in federally regulated banks are protected by reserve reporting and inspection requirements, and they're insured by the FDIC. One exception to this would be where certificates are sold by an investment firm and its money market subsidiary, Under that scenario, they would closely resemble investment contracts under Howey and likely be deemed securities. Guarantees. These are typically considered securities if they depend on cash flows of the issuer. So an example would be if a parent company issues securities guaranteed by one of its subsidiaries, or vice versa. Partnership interests and joint ventures and LLCs. This is important in the concept of Web3, and the rationale is that whether partners are active or passive in management of the enterprise. This has broad implications in Web3, specifically for DAOs, especially when they're unincorporated entities. And this is important for the last prong of the Howey test, which again was called the risk capital test. The reason is because when you have a general partnership and joint ventures, they are rarely deemed securities because general partners have an influence in the management of the enterprise. However, once you introduce the concept of both general and limited partners, that changes the analysis. And the reason is because limited partners don't have an active say in management of the enterprise. They're more dependent on general partners to improve the value of the enterprise, to grow it. And so under that circumstance, it would likely be considered a security. I suppose an exception to that rule would be if the general partners are inexperienced in business affairs, so they can't intelligently exercise their powers, or if general partners are dependent on unique characteristics of a promoter or a manager. And again, I go back to the DAO example of if you have an unincorporated entity, generally speaking, that can be considered a general partnership by default principles, or if you have an unincorporated association. DAOs, I feel we could do a whole series on DAOs, but that's why these concepts are relevant for the future, and it's best to educate the public on these. And so, LLCs, their organizational flexibility make this inquiry incredibly fact intensive. And the inquiry always hinges on the management structure. So if it's without centralized management, the equity interests likely are not securities. If it has centralized management where certain personnel are actively involved and the value of the enterprise depends on their involvement, it's more likely a security. We'll revisit this a little later as we go through the presentation. All right. So SEC guidance in digital assets, there is a plethora of enforcement actions for people to review and to get a good barometer of how the SEC looks at this emerging landscape. The Dow report, I think, would be very important. That was a decision handed down in, I believe it was 2017. Since then, there have been multiple enforcement actions to follow, but one of the most important regulatory guidance memoranda to come from the SEC is from FinHub. FinHub is, as it says here, the strategic hub for innovation in financial technology. They released a framework that can help the common public assess whether or not certain digital assets constitute securities or an investment contract. So we can drop a link, but if you want to go and search for this on your own, I would highly encourage you to go to the SEC website and you can just type in this framework for investment contract analysis of digital assets. The framework is really scoped around the third and fourth elements of the Howey test, which includes the risk capital test under the fourth element. So under point 4 here, reasonable expectation of profits, reliance on the efforts of others. Now, material factors within the framework and some of the terminology the SEC uses, what's important is something called active participant, and that means a promoter, a sponsor, a third party. So key questions to ask under the framework are, did a person or group of persons promote the creation and sale of the digital asset or the ecosystem? You know, do the APs significantly influence development and maintenance? Do they retain a stake or other interests? And are they motivated to expend their efforts to increase the value of the digital asset? Do investors rely on the APs to realize a profit? Do they expect to realize a profit over time? Or are they simply purchasing the digital asset for the functionality of the network or to purchase for goods and services? Do the active participants or promoters raise funds in excess of what's necessary to develop a functional framework or network? Do the active participants disclose how the funds will be used? You know, do they post that on a publicly facing website? Is there a white paper? What are the token economics? What is the token emission schedule? Is the digital asset instrument sold to the general public? You know, is it a general solicitation on publicly facing mediums, such as social media or their website? Does the token price correlate with the market value of the goods or services in the network? And what are the governance rights? You know, do the active participants or the promoters have certain rights that purchasers do not? Looking at the reasonable expectation of profits, the 2 points listed here are incredibly important. So capital appreciation and participation in earnings. Do the digital asset holders, the investors, share in the enterprise's profits? What is the secondary trading market for those holders to resell? Is that possible? Is the digital asset tradable or transferable in secondary markets, or are they locked for a certain period of time? Is it offered to the general public as a profit-making opportunity, or is it really promoted and targeted to specific users for services in the network or the network functionality? Transferability of the digital asset is key to figuring out the selling features. You know, other considerations would be, what is the intended functionality? What is the usability of the token? Are the token transfers restricted to the platform, or are they not available in external wallets? And what about repurchase programs? would the enterprise be able to repurchase these tokens at a discount from face value that was initially offered to the public? And what is the marketing and brand recognition plan for that network and that project? They emphasize token functionality instead of value appreciation. And so all of these factors taken as a whole, there's not one that's dispositive, but the SEC, through many enforcement actions and interpretation of the securities laws, provide this guidance to the public to create a framework for them for how to develop these networks and these new projects within Web3. There is quite a bit of legislation pending, and I don't know if all the attendees here have had a chance to review it, but one in particular is a bill that's being drafted by Senator Loomis. I believe the first cut has already been released, but that should be coming very soon. And one of the reasons that's very important is because it streamlines the regulatory landscape for digital assets. You know, right now what we're doing is applying existing law, old law that was written a long time ago. And, you know, for lack of better terminology, it's somewhat of a piecemeal exercise, because those laws were not written for digital assets or Web3. And part of the problem with that is it causes strain in the market. Innovation leads regulation, not vice versa. And so creating a framework, one that's comprehensive and consolidated, will help the market grow over time. So I would highly encourage people to go follow Senator Loomis or reach out to her. But we should have the first cut of that bill released to the public soon. All right, so with that backdrop in mind, now security token offerings. So what is a security token? You know, it has similar characteristics of a security, except that it confers ownership through the blockchain instead of, you know, paper documents as you would traditionally consider. Security tokens provide key financial rights to investors: revenue share, profit share, equity, dividend rights, and voting rights. Certain categories could include utility tokens, virtual currencies, commodities, and securities. Now, utility tokens are closely tied to functionality of the network or application. They give owners, holders, the right to actively contribute to the system. Virtual currencies, on the other hand, act as a store of value or medium of exchange. Commodities, which are not listed here, but are incredibly important, are a way to reduce barriers to entry and improve liquidity to entry in asset classes when converting digital assets into tradable assets, or converting physical assets, like gold. An example would be a commodity collateralized stablecoin backed by a commodity like gold. The commodity would guarantee the value of the stablecoin, and ownership would represent a claim to the collateral. In other words, the investors would be able to exchange their stablecoin based upon a predefined conversion rate. Securities. So these can take many, many forms. Asset-backed tokens, which would be a token that represents a claim on the underlying asset, that allows trading the asset without having to encumber the underlying asset back into token. Share-like tokens, that would be where the issuer promises holders a share in the success of the enterprise. You know, so that would be revenue share, profit share, equity, dividends, or voting rights. Debt instruments, or debt interests, and equity instruments. Tokenized debt instruments would be corporate bonds or real estate. The value of the security depends on the risk and dividend. Risk would be value fluctuation or debtor default, and dividend value is dependent on the regular income of the underlying debt instrument that it will generate over time. So an example would be, an issuer issues a debt instrument. It's backed by a real world asset, such as real estate, and it provides a utility to the investors. That's allowing investors to invest in tokenized real estate. They don't own the real estate, but they own the debt instrument that is backed by the real estate. And it's evidenced by that debt instrument. This is a budding sector that we will see in the coming years. The potential is extraordinary. And then last but not least are equity interests. So as I was mentioning earlier with corporations, partnerships, LLCs, and joint ventures, this I think will be relevant as well, but for different reasons. So this would be an obligation of the issuer or a share or other interest in the issuer's enterprise or in their property. Traditionally speaking, that would be a security certificate and bear a registered form. One of the areas of great importance will be uncertificated shares that are issued on the blockchain. And that would be in classes and series. This has great potential, like real estate with debt instruments, because you can purchase whole or fractional ownership. An example would be if a company issues a class or series of stock, but you don't have the requisite funds to pay for an entire share. One could pay partial consideration, and the issuer, along with that certificate, would also issue a script or warrant. Once that holder is able to pay full value, full freight for that asset, they would surrender the script or warrant to the issuer, and then in exchange, they would receive the full value, a whole share. This enables fractional ownership of equity interests in enterprises. And by the same logic, you could apply this to debt instruments like real estate. This is one of my favorite parts of asset tokenization because it lowers barriers to entry across the entire economic spectrum, from enterprises to the unbanked and underbanked. This will allow for more money to enter the market, and through security token offerings, which is what we'll get to later with Ethereum security token standards. All right, so security token offerings, what are our options as of today? So we've got 5 listed here, and I'll go into more detail through these slides. So Regulation A and A+. This is exempt from registration for public offerings, and it comes in 2 tiers. Tier 1 is up to $20 million, and Tier 2 would be $75 million. The procedure would be the issuer would file an offering statement called a Form 1A with the SEC, and that would have to include an offering circular for distribution and all required exhibits. A Form 1A is similar to a registration statement. And securities sold in a Reg A+ offering are not restricted, meaning they can be freely resold in secondary markets. Certain Reg A+ offerings are exempt under blue sky laws, so you don't have redundant filings at the state and federal level. But importantly, what is not exempted under blue sky are anti-fraud provisions. Rule 506B, private placements. So 506B comes under Regulation D. It's considered a safe harbor that provides standards for a company to meet requirements of the Section 482 exemption. It's subject to the bad actor disqualification under 506D, which I'll get to in a little bit. Now, 506B offerings are unique. They allow issuers to raise an unlimited amount of money from a limited amount of accredited investors. Some limitations, though, include no general solicitations or advertising, and offerings are limited to 35 non-accredited investors. Some of the requirements for these offerings include disclosures akin to Reg A, Issuers must provide non-accredited investors financial statements, and they need to make themselves available to answer any pertinent or material questions from non-accredited investors. 506B investors or purchasers receive restricted securities, which are not available for sale and are not tradable in a public secondary market. That resale of restricted securities is subject to separate exemption requirements. Issuers must file a Form D with the SEC within 15 days after the first sale of a security. I will 16. And actually, before I move forward, one important point here is the use of private placement memorandums. That would be akin to a term sheet, a non-binding term sheet, or LOI, letter of intent. The reason is that the information contained in private placements very closely mirrors what you would have in a registration statement. And so if an issuer were to be subjected to a complaint from an investor, one very good way of meeting requirements is through a private placement memorandum. Because it mirrors what you include in a registration statement, that significantly bolsters the argument and your position as an issuer that you followed the offering requirements to a T and the registration requirements. All right, Rule 506C, general solicitation. So as part of the Jobs Act of 2012 from President Obama, it permits general solicitation and advertising for offerings. The catch, however, is the investors must be accredited, and issuers must take reasonable steps to verify that status. And that could be through civil W-2s or bank statements from the investors. 506C purchasers receive restricted securities. So again, not available for resale in secondary markets. And they must file a registration statement. So again, private placement memoranda is a great way to get two birds with one stone. The 504 small issuance offering. So this is an exemption for offerings that do not exceed 10 million. This is less popular and it's significantly overlapped by Reg A and A+. And again, it's subject to the bad actor disqualification. So what is the bad actor disqualification? It disqualifies offerings relying on a 504 if the issuer is a covered person that has experienced a disqualifying event. So covered person and disqualifying event are important terms. You know, a covered person would be an issuer, predecessor, or an affiliate issuer. Directors, officers, general partners, or members, beneficial owners of 20% or more of the issuer's outstanding voting equity securities, and that's calculated based on voting power. Promoters connected with the issuer in any capacity at time of sale, and people that are compensated for soliciting investments. And that would also include general partners, directors and officers, or managing members. A disqualifying event would be something of significance, like a criminal conviction, court injunctions or restraining orders, final orders from state and federal regulators, SEC disciplinary orders or cease and desist orders, and so on and so forth. Now, disqualifying events are subject to a look back period, and that hinges on January 20th of 2017. The reason is that is when the 504 amendment added this language to the statute. If there is any disqualifying event that occurred prior to that date, an issuer must disclose that to investors. They're not subject to the requirements or the exclusions of the law, but they still must disclose those events. All right, and last but not least, there's regulation crowdfunding. So these are unique because they're tailored more to retail investors. Some of the requirements: all transactions must take place through an SEC registered intermediary, such as a broker dealer or a funding portal. The amount is limited to $5 million in any 12-month period. And it limits the amount individual non-accredited investors can invest. So individuals with an income or net worth over $107,000 can only invest the greater of 2.2K or 5% of the lesser of their net worth or income. Individuals with both an annual income and net worth of greater than 107K can invest up to 10% of the lesser of their annual income or net worth. And in all of those circumstances, it's capped at 107K. That is the key term. And like the other offering options, it's also subject to the bad actor disqualification. Okay, so in a nutshell, what's very important for security token launches are issues that need to be considered. White paper, first and foremost. Does the content in the white paper show that it's an offering for tokens that would be considered investment contract under Howey, applying those 4 elements? Token issuance. What's the number, the price, the emission schedule? Does it represent a debt or equity interest? Do holders benefit from assets or profits of the enterprise? Marketing and brand recognition. Is it a general solicitation to the public? Is it tailored to specific investors? Do they use a portal? Who are the purchasers or the investors? What is their identity? What are their expectations? Is this a profit-making opportunity, or is it for consumptive use? And then secondary markets, transferability, resale, and so on and so forth. Okay. Ethereum security token standards. So a lot of these are incredible innovations, and we will see many of these in the coming years. There already exists many projects that utilize these. So ERC 1400, this implements the partial fungibility property, and that allows for performing corporate actions such as doc management, controller ops, M&A, and these are all essential for financial assets. ERC 1400 represents a library of standards, and they include ERC 1410, which allows for differentiated ownership and transparent restrictions, ERC 1594, on-chain and off-chain transfer restrictions in issuance and redemption semantics, ERC 1643 for document and legend management, and then last but not least, ERC 1644, controller operations or a force transfer. ERC 1404, this is a self-regulatory token or a restricted token standard. It allows for whitelisting. It's appropriate for crowdfunding because it limits the investment amount limits, allows for token lockups, and that preserves the value of the token, and it allows issuers to meet complex regulatory compliance requirements. ERC 1450. This is ERC 20 compatible, and it manages securities ownership and trades in compliance with Securities Act Regs A, D, and CF. Only the contract issuer can create 1450 tokens and assign the registered transfer agent, or the RTA. This is important because only the RTA is allowed to execute the mint and burn functions for that token. whereas an SEC registered broker-dealer would complete the transfer functions post-trade. This is one of the budding areas with security tokens, and I think will be relevant in the future. ERC 884. So like the previous one, it's also ERC 20 compatible. And this is scoped to the Delaware General Corporation Law. Title 8 of the DGCL allows Delaware corporations to use blockchain to create tradable tokens and maintain shares issued by a Delaware corporation. And like I said earlier, with equity interests, this allows for whole and fractional ownership. And if you're going to purchase shares, partly purchase, that would involve the issuer issuing scrips and warrants along with the tokenized shares until the full freight is paid by the holder. ST20. So built by Polymath, this is a security token issuance platform that connects financial securities in the blockchain. ST20 would be synonymous with ERC 1400 and 1410. And this is notable because the platform is built on a decentralized protocol and it manages the whole life cycle for the security token, from creation through offering. The R token is a permission token. It was built by Harbor, and transfers are controlled by the on-chain regulator service. The R token includes three core components: token, regulator service, and the service registry. This is notable because it meets various regulatory requirements. It simplifies AML KYC onboarding, accredits investor status, and allows issuers to meet the requirements of the securities laws, rules, and regs, as mentioned earlier. SRC 20, this is also ERC 20 compatible. These are built on Token D and the Stellar blockchain. And this was designed by the Swarm Fund. It's a real-world asset tokenization platform. Another way of saying this is real-world objects can be set as tokenized assets, like we went through earlier. And then last but not least, you have the DS token, also ERC 20 compatible, or excuse me, this is an ERC 20 token, and it's based on the Digital Securities Protocol. This provides integration solutions for fundraising, automation, and liquidity for financial assets. Tokenization benefits. So up until now, we've covered a lot of content, but the market opportunities here, I believe, are endless. Tokenizing debt and equity instruments, for one, will reduce costs. It will streamline due diligence, enhance liquidity, automate AML KYC, and permit secondary market trading. Automating token controls for compliance with securities laws is incredibly important. It will reduce the cost of implementation across the market, lower barriers to entry, and it will penetrate market segments that have not been done before. That includes unbanked and underbanked through whole and fractional ownership. But it also will enable market participants to engage in more capital and liquidity transformation. So a few examples I've included here. If you look at 6 through 8, reduce settlement cycles and counterparty credit risk. Looking at capital markets today. So one example would be the tri-party repo market, and that's a way for the incumbents to finance their inventories of securities. Web3 and blockchain in general operates 24/7, 365. It does not operate with the markets from 9:30 until 4:30. Anyone who satisfies the prerequisites can trade at any time. And this will significantly alter the landscape. So to give you an example, capital markets, repurchase agreements, sec lending or securities lending, and prime brokerages. One of the problems today is it's difficult to determine net exposure and credit risk for banks and broker dealers. So one of the solutions through blockchain is improving settlement cycles from T+3 to T+0. That significantly improves settlement risk transparency, and it reduces counterparty credit risk. Some of the benefits, in addition to what I've said, include advanced credit exposure netting, adjusted capital requirements, trade execution, all of which are streamlined because of blockchain technology. Another example I believe would be if you look at broker-dealer services today, where variation margin threshold is incredibly important. Reconcile on a daily basis. And when you use certain types of collateral, each one of those will have a rating. Cash and cash equivalents would be 100. The lower rated, meaning the higher risk assets, have a higher haircut. A haircut is determined by, you take your initial margin with your variation margin, the haircut would be the difference. And so if you look at 100 for cash and let's say an A rated or a triple B, maybe that's 105. And so your haircut is the margin you have to maintain on a daily basis to over collateralize, to reduce risk. Allowing blockchain into this realm will significantly streamline not only capital and liquidity requirements for institutions, but it also introduces many examples and opportunities that were not possible even just a few years ago. And so systematic record keeping, reducing cross-principal netting exposure and adjusting capital through automation and smart contracts will penetrate the market in the years to come. And it's very, very exciting. The last example, I suppose, would be synthetic registries. So residential and commercial property transactions, mortgages and land titles. Today, it's more of an outdated and incredibly labor-intensive and risky process. When you have to engage in title reviews to make sure you have clean and marketable title, that often involves insurance and attorneys, which legal fees, and that can be astronomical depending on the size of the transaction. Automating this with blockchain significantly improves that process and it lowers the cost. And so that increases capital for those parties that can be employed or rehypothecated elsewhere. It also improves transparency at an aggregated level because it allows for authenticity through multiple vantage points. And so this is another area that's very exciting. So last but not least, with share registration, governance of fund management, as I said earlier, I think that's also an area with tremendous promise. That is all we have for this webinar. This is the first of 5. So I want to thank you for everyone for attending. If you have any questions, feel free to reach out to me. Stay tuned for the other webinars. I've listed them here. I don't know the cadence off the top of my head, but we will certainly cascade that to everyone. The next webinar will be presented by my co-chair for this interest group. His name is Daniel Narkin. He's the founder and CEO of Envision Blockchain. And then following that, we'll focus on tokenomics, ethics, and then we will apply all of these concepts to industry use cases like real estate, capital markets, and repo markets, telecommunications, and so on and so forth. So I hope everyone enjoyed this. Stay tuned. We'll have a brief Q&A to follow for EEA members, and I look forward to seeing everyone in the upcoming webinars.